In hiring new employees, it's important to follow government-required procedures to ensure that your company is lawful in its employment practices. One legal issue that has gained recent media attention is immigration compliance. The Immigration and Customs Enforcement Division, or ICE, has recently increased its efforts to prosecute companies that violate immigration law. In 2006 alone, ICE made more than 700 criminal arrests for knowingly hiring illegal aliens, an increase from only 25 arrests in 2002. As the government continues to crack down on immigration enforcement, many employers face hefty fines and jail time for these criminal violations. Welcome to CSO's Immigration Compliance Program. As an employer, it is your responsibility to understand the Immigration Reform and Control Act, the associated documents and procedures, and how to prevent common immigration issues. In this program, you will learn about the I-9 form, acceptable documentation, and how to prevent immigration discrimination. You will also have a chance to review common non-compliance issues and test your knowledge on how to handle these cases. Finally, you will receive practical tips to adequately comply with immigration laws. Don't fall asleep, there's a test. The Immigration Reform and Control Act of 1986, or IRCA, requires all U.S. employers, regardless of size, to verify the identity and employment eligibility of all employees hired after November 6, 1986. It is unlawful to knowingly hire or continue to employ unauthorized workers. To be compliant, all companies must complete the Employment Eligibility Verification Form, or I-9 form, for all employees, including U.S. citizens. As in many cases, there are exceptions to this rule. Some individuals are exempt from completing the I-9 form. If a company hired someone on or before the law went into effect, and the person has continuously worked for the company doesn't need to complete the I-9 form for that employee. Additionally, an employer does not need to complete an I-9 form for anyone providing domestic services in the home that are sporadic, irregular, or intermittent. And the I-9 form does not need to be completed for services by true independent contractors, or workers under contract, subcontract, or exchange. The I-9 is a three-part document. Employers are responsible to ensure completion of the entire form. When you hire a new employee, the person must complete Section 1 of the I-9 form by close of business on the first day of work. The I-9 form is published in English only. The employee's signature holds them responsible for the accuracy of the information they provide. It is your responsibility to ensure the employee completes Section 1 of the I-9 form. As an employer, you must complete Section 2 of the I-9 form by end of day of the employee's third day of work. You complete Section 2 only after verifying that the employee is who he says he is and that he is authorized to work in the United States by reviewing one or more of a number of acceptable documents that are listed on the I-9 form. Unlike tax documents, you are not required to send I-9 forms to the government. Once you complete the I-9 form, you must keep it on file for 3 years from the date the employee is hired, or 1 year after the date the employee is terminated, whichever is later. I-9 forms can be stored at the company headquarters or other related offices. The documents must be able to be retrieved from storage within 3 days of an official request of the documents for inspections. The law does not require that the I-9 forms be stored in the employee's personnel file. As a matter of fact, it may be difficult to retrieve all employee I-9 forms from individual personnel files in time to meet the 3-day deadline for inspection. Therefore, it is recommended that all current employee I-9 forms be kept in a notebook in alphabetical order. You should also keep separate binders for both current and terminated employees. Finally, it is good business practice to audit your I-9 forms annually. This will ensure that you catch on a regular basis situations in which a List C document has or will be expiring, or a situation in which you gave the employee additional time to produce a document and then failed to follow up on its whereabouts. A pattern of regular audits will also signal to the U.S. Department of Labor, in the event that they ever audit your I-9 forms, that you have made consistent attempts to be in compliance with the law. It is important to follow record-keeping requirements to both defend a claim against unlawful employment and a claim against unfair hiring practices.